Court, Saint Lucia, hearing of application in LCACV number 1 of 2023 between McDowall Broadcasting Corporation, MBC Limited, and Guy Eardley Joseph. The members of this morning's panel are Mr. Justice Saunders, President and the presiding judge.
Good morning, everyone.
Mr. Justice Anderson.
Good morning, Council.
Mr. Justice Barrow.
Good morning, my fellow Lucians.
Mr. Justice Burgess.
Good morning, Council.
And Mr. Justice Jamadar.
Good morning to everyone.
May we have the appearances, please? Thank you.
May it please you, President and my lords, alias M. Antoine, along with Mr. Kenroy Justin, for the applicant in this matter, McDowall Broadcasting Corporation, MBC.
Yes. And who is appearing for the other side?
May it please the court, my name is Vanessa Pinnock, and I appear along with Mr. Mark Maraj on behalf of the respondent in this matter, Mr. Guy Eardley Joseph.
Okay, thank you very much for your appearances. It wouldn't be lost on you, it's certainly not lost on us, that this is the first matter which we have been pleased to receive from the state of Saint Lucia, and therefore, in some sense, this is an historic occasion. So I warmly welcome Saint Lucia and Council to the Caribbean Court of Justice, and we look forward to a long and fruitful relationship between the court on the one hand and the state and the people of Saint Lucia on the other. The second prefatory matter had been addressed, I think, sometime before, and that is, as you all are aware, Mr. Antoine is a commissioner of the, he's a member of the Regional Judicial and Legal Services Commission, but of course, the judges of the court, save myself, who preside over the commission, are independent of the commission in our adjudicating, and I know that this matter had been ventilated before. Mr. Antoine, are you ready with your submissions?
My lord, I am.
Yes. So please proceed.
Thank you, my lord. My lord, as part of this application, the court has asked us to specifically address the issues of limitation under common law versus prescription under the civil code. And that is what we have sought to do this morning. So our contribution this morning's submission is very limited in its scope in addressing those issues. The Civil Code of Saint Lucia prescribes and extinguishes all causes, remedies not properly before the court at the expiry of the prescription period. And that is really found in Article 2129 of the Code, which says in all cases mentioned in Articles 2111, 2121, 2122, 2123, and 2124, the debt is absolutely extinguished and no action can be maintained after the delay for prescription has expired, except in the case of promissory notes and bills of exchange, where prescription is precluded by a writing signed by the person liable upon them. The particular point before us is one of defamation, and Article 2123 prescribes defamation be 1 year. For slander or libel, reckoning from the day that it came to the knowledge of the party aggrieved. Well, we start off with a judgment of Piddikin, Justice of Appeal Piddikin. And the judgment could be found at page 202 of 292 of the bundle. The judgment is one of Norman Walcott and Moses Seri, Civil Appeal number 2 of 1975. And it really expounded on the limitation as opposed to prescription points. And at page 4 of the judgment, which can be found at page 205 of 292, Pitikin J.A., and I quote read, a close study of the ratio descendi in the Rodriguez case discloses that Neil J. held that limitation acts in England can properly be regarded as dealing with practice and procedure rather than conferring substantial rights. Indeed, at page 363 of his judgment, we find these words. And he goes on, the benefit which a defendant derives from the statute of limitations, is not, I think, properly described as a substantive benefit, but really merely a right to plead a defense if he chooses to, so that the plaintiff is barred from prosecuting his matter or his claim. And he went on to say, using our code, in Article 2129 quoted above, both the right and the remedy are extinguished, and therefore there is no question of a party being called upon to choose whether he would plead a defense of limitation. And I emphasize, as long as the evidence in a case discloses that the period of limitation has expired, the judge has no discretion in the matter. And that's emphasis that was added.
I don't think that there is any dispute, Mr. Antoine, about the length of time for the prescription period to run. I think the issue is there, can you point us to any articles in the code that speak to how and when prescription can be interrupted?
I did not seek to address that point, my lord, in the submissions.
Okay.
As I said, I kept it very narrow as I understood the question was limitation versus prescription. I didn't address that point there. But there is a section in the code with this interruption. But my lord, one would need more to add more case law in a case like that to explain how the courts have explained judicial interruption. Because the code does speak of judicial interruption, but there are different cases who interpret what judicial interruption is and how it could be done. And there is also another section in the code that speaks about who looks at really what is a judicial demand and in what proper form it can be taking place as well. But I did not address that at all in the speaking notes.
Yes, the other side's speaking notes cite Article 2085 that says a judicial demand in proper form served upon the person whose prescription it is sought to hinder, or filed and served conformably to the code when a personal service is not required, creates a civil interruption. So that if there was service upon the person whose prescription it is sought to hinder, or filed and served conformably to the code when a personal service is not required, then that creates a civil interruption. I suppose your argument is that there was no proper judicial demand served on your client. Is that the case?
Yes, that is our argument. No proper judicial demand was served on the client. And in the case before the court, who was served was a secretary, another corporate secretary. And for companies, the requirement for service is either you serve the registered office or you personally serve. So that's where it comes in. You personally serve the corporate secretary, an officer of the company, or which includes a director of the company. And that is a requirement. So personal service does come to play in there, because for a company, you don't require personal services on the registered office, but for the personnel or officers of the company, you require personal service on them.
But the company entered the defense within the period during which you say that the prescription period was running.
Yes.
So that did not serve to interrupt prescription.
No, it did not, because the service was not proper.
Mr. Antoine,
Yes, my
I
lord.
think any of the civil practice texts will tell you, according to their understanding of the civil procedure rules, that an acknowledgement of service and more, the filing of a defense, waives any irregularity or procedural defect in service. In fact, Blackstone Civil Practice 2019 or whatever quotes a case which says that, sorry, let me just, the case is Brooks against A.H. Brooks. Brooks against A.H. Brooks and Company. And the citation is 2011, 3 All England 982. In that case, there was in fact no service upon persons, but a firm of solicitors entered an acknowledgement of service for the said persons. The firm was duly entitled, authorized to enter an acknowledgement of service by a formal document. And there was a challenge to that service. And at paragraph 19, the judge said that the firm were entitled to and did acknowledge service on behalf of both the complainants. And in my judgment, both of them are bound by that acknowledgement, which waives any defects in service, paragraph 19. So this is what is in fact engaging me, that whatever irregularity there may have been, the acknowledgement of service, and I think even more so, the entry of a defense and engagement with the claim, which it is now sought to say was interrupted, waived any defect, any irregularity in the service. The Court of Appeal purported to correct it. And I'm suggesting to you on this reading, I have not made up my mind, just bringing the learning to your attention, suggesting that on this reading, there was in fact not any need to correct anything because there had been a waiver of that which was irregular. Tell me your thoughts on that.
Lord, my lord, I really wish that, and perhaps it's my fault, that I had understood the question the court was asking from the very outset. We had made submissions in the matter while filing the application, and we raised several points in our application. And the court came back to us to indicate that the court wishes us to address the narrow issue of limitation on the Commonwealth versus prescription. And I understood the court to be asking, what is the difference between the two? And that is what I sought to address this morning in my speaking notes. Had I known or understood the court to mean that we are ventilating the entire matter and whether or not there was proper judicial demand, or we're not entering a defense to a claim amounts to a waiver, I would have addressed that in the notes and in the submissions, because there are cases from the Supreme Court. In fact, one of the cases we use below, which is a very persuasive case from the English Supreme Court, was the Barton case. And in that case, the Court of Appeal had a different view when it comes to an originating motion in terms of a claim as to how it could be started and what is proper service and whether or not one could exercise discretion at all, and issues of a waiver. All that was done in the Barton case. So I wish I would have had the opportunity to put before the court some elements of this matter. I'm not saying the court will not have a different view on the matter, but I really wish I would have had the opportunity to address the court on all those issues. As I said, it may just be my fault, but I understood the court to be asking by the court's order which we received to say, and I read again, the court says parties are to file speaking notes concerning prescription and extinguishment of cause of action under Saint Lucia Civil Code as opposed to limitation of time on the common law principles. All submissions at the hearing of the application shall be limited to prescription and extinguishment of cause of action under Saint Lucia Civil Code, as opposed to limitation. That, to my mind, my lord, and as I stated, seems to be very narrow as to what the court wants us to address this morning. And I really did not understand the court wants to address the other issues. So I'm really blindsided as it speaks, my lord, at this moment.
Okay, but the order that was sent out did indicate that the application for special leave was going to be addressed today. And yes, I accept that the order said that the parties that have filed speaking notes concerning prescription and extinguishment of the cause of action on the civil code, as opposed to the limitation of time on the common law principles, and so on, and how you must set out those things. But putting all of that aside, this morning we are addressing not only that particular issue that we are particularly concerned with, but also the general application for special leave. And of course, one of the major grounds for justifying special leave is that you have some prospects of success. So we need to hear from you what prospects of success you have in a case like this, where a defendant who received notice of the proceedings, filed an acknowledgement of service, defended the matter, issued a defense to the matter, as we understand it, engaged in mediation. I'm not sure whether the mediation efforts were within the period of time prescription might otherwise have been running or outside. The defendant will tell us about that the other side. But why is it that a defendant who has gone through, who has undertaken all of those steps, is not entitled to say, or the other way around? Why is it that it couldn't be said that prescription has been interrupted by all of those steps that were taken by the defendant?
Sorry, Mr. Antoine, before you respond to the president, in terms of your being blindsided, I am sympathetic to the indications you have given. However, I draw to your attention the speaking notes of your opponent, who started off right away with Article 2085, to which the president earlier referred. And in the course of their speaking note, they deal with the question of renunciation of prescription, and they deal with the matter of abandonment, waiving any right which may have acquired to the defense of prescription, citing cases, etc. So as I said, I'm sympathetic with your focus, but it does seem to me that what we asked included the matter of the extinguishment or the extinction or renunciation or interruption of prescription. But do answer the president.
Thank you, my lord. My lord, I support my lord's argument on the aspect of having joined in the cause of the matter. However, the rules does allow that, notwithstanding one has joined an acknowledgement in the matter and even a defense, that one could take issue with an issue of jurisdiction. And again, I wish I had the opportunity to put forward the case law, which distinguishes the two forms of jurisdiction. One that deals primarily with foreign aspect of jurisdiction, and one that deals with what we call probably local jurisdiction. In that, a point of jurisdiction, when it comes to a point of law, as in the case of prescription, can be taken at any time, notwithstanding one has joined in the matter. Our submission is that there was not proper service from the outset. And because there was no proper service, notwithstanding all that we've done in joining the matter, that does not preclude us from taking the points on prescription. And that is our simple point. And again, I say to the court that I wish I understood the question better so I could address all the issues. And I take the court again to my 1.2. It says the hearing of the applicant shall be limited to prescription extinguishment of the cause of action. On that word limited, I sought to be disciplined in keeping it within the bounds of what was put before me, or what I understood was before me. And I do apologize to the court this morning because I feel somewhat constrained in responding to the court on those issues and not having the proper case law. And this, because these are issues when I understood, I thought what the court was doing this morning was hearing this as a preliminary point. And if the court was satisfied there is a difference between limitation and prescription, then we would go on to deal with the general application, where we have done research. We've dealt with cases of Barton, we've dealt with the issues of renunciation, and look at it, and whether or not renunciation in the code there speaks about negative prescription or positive prescription. These are questions to be answered. And if one says prescription extinguishes both the rights and the cause of action, then one begs the question: can one renounce something that may have already taken place? So these are the questions we wanted to put we wanted to have the court look at and come to a decision on, and we think was of general importance. Just the point of prescription: can one seek to cure? Can one use the discretion to cure a prescription matter? All those different elements we wanted the court to deal with.
But when the defense was issued, duly signed by the attorney at law for the defendant, the prescription period had not expired.
No, it had not, my lord.
And so is it open to a defendant if there's, say, as in this case, a 1-year prescription period? You file an action is filed against the defendant, and for whatever reason, the 1-year period doesn't mean that the case must finish within 1 year.
No.
So is it open to a defendant after the expiry of 1 year and several motions or nothing happening on the case, that after a year has expired, that you simply move a motion and say, well, a year has gone, and the limitation period, the prescription period is 1 year, and therefore you must throw out the matter because you have no jurisdiction, a year has elapsed?
No, I don't think that was our argument. Our argument was, sorry,
no,
our argument really.
The reason, just a minute, the reason why you can't do that is because, notwithstanding a year has elapsed, things have happened that have interrupted the prescription period. Is that correct? The reason why a defendant in the course of proceedings cannot, after the time the prescription period has run and the proceedings are still going on, cannot suddenly say, aha, prescription period has expired. I move a motion now to have this matter dismissed because no judgment has been entered as yet and the prescription period has expired. The reason why you can't do that is because, notwithstanding chronological time has expired, things have happened that have caused the prescription period not to any further, not to be running. And so, coming back to this case, the question is whether any things have happened that have caused the prescription period to, as they say in the code, to be renounced. And if so, what are those things? Or if not, why those things do not amount to the prescription period having been renounced? Why is it, you need to tell us, why is it the entry of a defense is not a document that or the acknowledgement of service that renounces the prescription period.
My Lord, our argument is not quite that. Our argument is that from the very beginning, service was not proper, so the originating motion of the claim has never started. So it has never started.
Yeah, but if it didn't start, then why you file a defense?
We mistakenly filed a defense, and that's our argument. We entered appearance in the matter on the belief that it was properly served, and we later realized it was not properly served. So we took the point that it was not properly served, and the claimant had never sought to go to the court to remedy the service, to make it proper service. And that's why I fall back to the Barton case, the Supreme Court, that indicates that there must be proper service for the matter to start. So if this matter has never started because of the proper service, then everything that follows from there is void as well, because it cannot go.
Sorry, Mr. Antoine, did you use the word void?
Or probably perhaps irregular might be the better word.
Sorry?
To use.
But Mr. Antoine, that's a very fundamental distinction. You see, the difference between it being a nullity and it being an irregularity is at the heart of this. If service is if the defect in service is a nullity, then the consequences are different from if it was an irregularity. So maybe before we go further, would you say that in this case, the service under the Companies Act, if there is some defect or shortcoming in service, that amounts to an irregularity procedurally? This is procedural law for the moment.
Yes.
Would you say that is an irregularity? So
yes,
we're not in the realm of limitation and prescription. We're in the realm of procedural law in the CPR. Is it an irregularity or a nullity?
No, my Lord, I will accept that's the irregularity.
Okay, so if it is a irregularity, then it is curable. Agreed?
Indeed, my Lord.
In the exercise
hold on,
let me interrupt.
You therefore withdraw the word void.
Well, I referred void in the respect of the subsequent matters that were filed, not the claim being void, but the defense acknowledgement of service being void. To the point
what makes them void if what took place is an irregularity and not a nullity? What makes that which flows from the irregularity, the not void proceeding, what makes them void?
Well, until the irregularity is cured by the courts, I am submitting that the acknowledgement of service and the defense cannot or should not be taken into consideration because of the irregularity of the claim in the first place. So
an irregularity has a tainting effect to make that which follows void. That is what you're saying.
That is what I'm saying, my Lord.
Okay, Mr. Antoine, I commend you for your boldness.
Yes.
But Mr. Antoine, can I just take our brother's conversation 2 questions further? And if the irregularity is cured, what does that do to any potential rendering of voidness?
No, if it's cured, then the matter all is well.
Okay.
All proceed.
It ceases to be void.
It ceases, right? Well, it was never void, I think. I think the possibility of it being void. All right.
Mr. Antoine, really.
We could use irregular. We could use irregular.
Yes. So that the curing of the irregularity, as you said, to use your language, everything is back in order. Yeah?
Yes.
And in this case, if the service was deemed to be irregular and by exercise of judicial discretion cured, then the service would be in law regular.
Yes.
All right. So
okay.
I won't ask anything further for the moment. I don't know if I think our brother Justice Burgess wants to ask something.
Yes, Mr. Antoine, just following on from Justice Zamadar's line of questioning. Are you saying that the irregularity was pursuant to the provision in the Companies Act, and that as a result of that, it was not curable by the court using Rule 26.9, I think, of the CPR. What exactly is the relationship between the provision with respect to service in the Companies Act and the power which is given to the court on the CPR to remedy irregularities?
Yes. Well, both the CPR and the Companies Act makes provision for how service should take place, and they're similar. The Companies Act is statute. We'd argue the court below that because it's statute that it's mandatory. The court held the position there's the word may in the wording of the statute, so it allows other ways of service. We don't quite hold that view, but we're not going to waste the court's time on this. So the court does have a discretion to cure. We're not doubting that. The court has discretion to cure. But there are 2 points, and I wish I could have addressed that point by case law. Under English law, even in the Batten case came out, and the case is not before the court, one can cure service retrospectively. I should say one could not cure service retrospectively in the UK. Notwithstanding the court has inherent jurisdiction of similar provisions on the CPR rules, simply because the rules does not allow retrospective curing. They don't allow retrospective curing because the rule speaks about looking forward. That's respect of curing issues originating motions. That's very clear. Because similarly on our rules, if you can't find someone to serve them as per the rules, then you could use an alternative method of service, right? And you normally go to the court to sanction your alternative method of service. And that happens in the UK as well. The UK has since changed the CPR rules to allow retrospective curing of bad service. On our CPR rules, there's no such provision has been done on our rules. So that's 1 point. Secondly, the curing of the discretion, extended discretion to cure came at a point where prescription already set in. And it's our submission that having set in, it means that the rights and the cause of action has already extinguished. So if it's already extinguished, then there's nothing to cure.
Okay, while we're on the subject of curing, can a defendant cure an irregularity in service upon him or her or it?
I don't think so.
No? So you have a counterclaim and you were served inappropriately. They left it at your friend's house and not your house. But your friend said, hey, boy, somebody left this at this house. And it looks like it's for you. And you get it, and I'm happy that he sued me because I have a counterclaim against him. And you file a defense and you put in your counterclaim. That counterclaim is a nullity.
Well, I'm saying that the provision was a nullity, it's irregularity. No, I wouldn't say it's a nullity. I wouldn't say it's a nullity at all. No.
Well, isn't the court entitled to embark on a hearing involving the claim and the counterclaim and to give judgment accordingly?
I suppose the counterclaim is an originating motion in its own right. Well, now it is. Under our rules previously, it was not. Only now our rules, as of July 1st, 2023, recognize the counterclaim as a separate and distinct claim. On our previous rules, it did not allow it whatsoever. So on our rules now, it's a separate claim. So as such, it's an original motion in its own right. But before July 1st, it was not originally a motion in its own right.
Okay, so in that event, then the counterclaim would be a proper document on which the court would be seized, but the claim itself, on which the counterclaim is a little parasitic, would not be a proper document because it was not proper served. The point is that the purpose of service is to bring in a proper form the attention of the person who is being served with notice that legal proceedings have been taken against them. And so it seems to me that the defendant here should have, because under the rules, apparently you do have to acknowledge service, but immediately upon acknowledging service, you challenge the validity of the proceedings.
Yes.
But here you almost string the other side along, you know, because you enter defense, you engage with them, you go to mediation, and then after a year has elapsed, you say, well, you know what, the service a year and a half ago was bad, and so your action is prescribed. Is there anything in the code that speaks to good faith in the conduct of civil obligations?
Yeah, the code presumes that good faith is presumed.
Good faith is presumed.
Yes.
Is that good faith on the part of a defendant?
Well, certainly speaking from the point of view of that this defendant, I could say it was good faith, because it was not a case where a defendant, but I, as counsel, along with my other counsel, is a point we realized that came up is we had, as my lord mentioned earlier on, we had an aha moment. It was just an aha moment. We were doing another matter, and then a similar point came up, and then we said, but wait, the matter had the same issue. So it was an aha moment, and we decided to take the matter to the court to be dealt with. So it was not a case of bad faith where we strung along the court and went on to the matter and then decided, oh, let's take this point after a year. It was a case where, while doing the matter, we realized, but wait, this was not proper service, and as such, it ought not to be before the courts. And we essentially took the matter to the courts on a point of law and had the court to address it. So it was not an issue of bad faith, but a point that came up.
And the master actually agreed with you?
Sorry? Yes, the master.
And the master actually agreed with you?
Yes, yes. I guess the master looked at it from a strict point of law and not any issues of bad faith, because there surely was not any form of bad faith whatsoever in the matter. As I said, it was an hour moment realizing, even before that same master, we had a similar matter that came up, albeit the prescription point was closer in time. But this one,
Mr. Antoine, may I just nuance something with you, please? You know, the idea of good faith, is it that good faith is not present when there is bad faith? Or does good faith have, in other words, you don't have to have malintent, you don't have to have an ulterior motive. Good faith is good faith the conducting of relationships, of proceedings with a certain degree of integrity, so that in this case the claimant files a claim and an acknowledgement of service is entered and a defense is filed on the merits, and there is agreement to go to mediation. I am also unclear whether in fact you went to mediation, but in other words, both parties are proceeding on an assumption that there are no technical defects in the matter, in the commencement of the matter. So it's not so that that is the content of the good faith. So that I am not sure for myself that somebody has to show mala fides to undermine the principle of good faith.
We'll put it away, my lord. There was no bad faith.
Well, fair enough. But
Yes,
what I'm saying is, you say that implied in the presumed in the code is good faith. Yes, what I'm asking you is it that good faith could be undermined without the necessity to prove bad faith? I don't think, as you have explained it, there was no bad faith. As you say, you had an aha moment, you took a point. But that doesn't answer the question of good faith. The question that good faith poses is this: even if you had an aha moment, given how the case had progressed, was that a moment that you should have taken action on? Or would that have been contrary to the good faith presumed in these proceedings? i.e., to be more technical, maybe by your actions, you had waived the right to take any points on an irregularity in service. That is how I suppose I would be exercising my mind around this good faith question.
I see force your argument, my lord. But I said, I certainly see point in your argument. It was a point of law, and I think as counsel, we have an obligation when points of laws come up, and we advise clients and we get instructions of clients to pursue the matter, and so we did.
Yes. Is there anything else that you wish to advance?
My lord, certainly, as I said, I would love if the court would allow. I mean, I think I see where the court is going, but I certainly would love the court to have our submissions on the issue of Barton, and talks about the Supreme Court decision, which is not binding on the court, but certainly persuasive, which really delves into originating motions as in claims, and indicates really that it ought to be dealt with differently from other matters, say a defense, a service. But an original motion is start a claim. The court is very clear that has to be dealt with differently, and then service has to be proper from the outset, and not simply trying to cure service afterwards, because everything that flows from the improper service in itself is irregular in that respect. And I would certainly have loved to put before the court that judgment and submissions on it, and to look at it, because as we did the court, I understand this is the apex court, but the court below did not deal with the prescription point. The court below sought to cure the irregularity. The court accepted below that there was a irregular motion. I understand the court say, well, I don't think there was any irregular in the first place, because by filing defense and joining in the matter, you've essentially waived your right, and as such, everything was cured by this filing this. But I would wish the court to see those submissions and go for them. Yes.
If I were to seek to persuade my colleagues to go with your request, how quickly would you put in those submissions?
Within 7 days, my lord.
Okay, thank you.
I would just love the court to have wherever it falls, but certainly a full judgment on the matter.
Appreciate it.
The point is properly ventilated.
Mm-hmm. Yeah. Okay. Yes, is that it?
Yes, my lord. Unless I could ask, and the court has any further questions for me.
Yes. Okay. Thank you, Mr. Mirage or Ms. Pinnock.
Good morning, my lords.
Good morning.
Must I proceed?
Yes, please do.
I will begin by outlining the articles of the Civil Code which are relevant to our proceedings this morning. I will start with Article 2123, which states that actions for slander or libel are prescribed by 1 year reckoning from the date it came to the knowledge of the party aggrieved. Article 2129, which states that in the cases mentioned in Article 2123, the debt is absolutely extinguished and no action can be maintained after the delay of prescription has expired. And however, my lords, both of those articles must be read in light of the following articles, which are Article 2085, which states that a judicial demand in proper form, which is served upon a person whose prescription it is sought to hinder, or filed and served conformably with the Code of Civil Procedure, when a personal service is not required, creates a civil interruption. Article 2088 states that prescription is interrupted civilly by renouncing the benefit of the period elapsed, and Article 2049 states that renunciation of prescription.
Ms. Pinnock, can you just give me the last one that says, what was the one before, after 2085? Article what?
2088, my lord.
And what does that one say? Sorry?
It says prescription is interrupted civilly by renouncing the benefit.
By renouncing, right? Yes. Okay. Yes. Mm-hmm.
Yes, my lord. And Article 2049, it states that renunciation of prescription is express or tacit. It goes further to state that tacit renunciation results from any act by which the abandonment of the right acquired may be presumed. Following from the articles above, my lords, it will be noted that the filing of a claim and the service of it the filing and service of a claim upon the party whose prescription it is sought to hinder are critical. It is clear from the facts of this matter, my lords, that our claim was validly filed. However, the issue which exists is in relation to whether or not service upon the applicant's receptionist was in an error in service, and whether that error in a civil proceeding is a procedural matter, which the court has the authority under the under Rule 26.9 of the Civil Procedure Rule address on correct. Well, I will bring your attention to the case of Lisonia Corporation and against Consolidated Textile Mills, which I must express our apologies for uploading that case this morning as a part of our supplemental authorities. But my lords, in that case, the court explained that the essential question to what
which court was this?
the provisions of the Quebec Civil Code relating to prescription may curtail.
Which court was this? We have not had a chance to look at it, as you might expect. Which court was this? Lithuania?
Give me notice for just a moment, my lord.
The federal court.
This was the
Federal Court of Appeal.
This was an appeal from the Federal Court of Appeal in Canada, my lord.
Canada. Okay, thank you.
And what's the name of the case?
The name of the case, crave your indulgence.
Sorry. Lisonia Corporation. Lisonia, sorry, Consolidated Textile Mills.
It is a
Mr. Morant,
Lisonia
if you know the
Corporation.
name, yeah, thank you. Yeah.
Lisonia Corporation and Consolidated Textile Mills Limited and Consolidated Textiles Limited.
And you sent that in this one?
The Attorney General of Canada. Yes, my lord.
Okay. It hasn't been filed in the action as yet. Does it have a page number?
The page number that I'll be referring to, my lord, is, I will start on page...
No, I mean a page number that, has it been filed in the proceedings?
In the CCJ record?
Yes. Page 456, it begins on page 456.
456, okay.
The case starts in 455.
Ms. Pinnock, as we are just becoming familiar with this authority, can you help me in indicating whether it is from a jurisdiction in Canada, which has a civil code, more or less like that in Saint Lucia?
It is from the Quebec Civil Code.
Yes, my lord, as it is from the Quebec.
Quebec, okay, that's good. Thank you. Thank you.
Yes, my lord. So in the case, and it was explained that the essential question to what extent the provisions of the Quebec Civil Code relating to prescription may curtail the application of Federal Court Rules 424 and 425, under which the amendment was authorized. And that was an amendment in the case, my lord, in order to, as in the claim, my lords, the claim was filed on the holding company instead of the actual company. And so there's a question of an amendment to add the correct company to the claim. The court said in Dupuis and De Rosa, the Court of Appeal of Quebec stated the principles that if it can be seen from the substance of the proceedings that the true plaintiff has been a party to the proceedings from the beginning, even though it has been incorrectly described, this plaintiff must be permitted to correct the error, to regularize the situation, and to continue the proceedings. My lord, it is to be noted that, as a general rule, where the proposed appeal raises questions which are eminently procedural, these are not suitable for review by an appellate court, and are best left to the court of the jurisdiction to decide. And for that principle, my lord, we rely upon the case of Chia Thiem Sui, and I will
That is in your speaking note.
Yes, my lords. So that begins on page 323 of the file documents, and the paragraph I'll be reading from is on page 324 in the final paragraphs of that page. It says, my lords, their lordships have had the advantage of being referred to a large number of authorities which distinguish between judgments which are void and those which are merely voidable. Irregularities in the latter may be cured in the former, they may not. Their lordships would in any event be extremely reluctant to differ on a matter of New Zealand procedure under New Zealand rules from a decision reached by the Court of Appeal of New Zealand. But they are satisfied that the Court of Appeal's decision was right and that this was a defect which could be cured and that it was in the event cured as the Court of Appeal held. My lords, under rules 26.92 and 3 of the Eastern Caribbean Supreme Court rules, it is stated that an error of procedure or a failure to comply with a rule, practice, direction, court order, or direction does not invalidate any step which is taken in the proceedings unless the court so orders. It says also that if there has been an error of procedure or failure to comply with a rule, practice, direction, court order, or direction, the court may make an order to put matters right. In our circumstances, my lords, the actions of the respondent in serving the claim upon the receptionist of the applicant can only be considered as an error of procedure, and the Civil Procedure Rules makes it clear that such an error does not invalidate any step in the proceedings unless the court so orders. It is to be noted.
Maybe before you move on, let me ask you something. It's a question that our brother Justice Burgess had raised, and I just want to put it to you at this point. You say that the service on the secretary, who wasn't, I think maybe it is agreed, was not a corporate secretary or director. Is that an error of procedure under both the rules and the Companies Act, or is it an error of substance under the Companies Act? Would you just give us your responses to that, to those questions now, please?
Yes, my lords. I would submit that it is an error of procedure under both the Companies Act and the Civil Procedure Rules. And in order to support that view, my lords, I would mention that Rule 5.7 of the CPR and Section 521 of the Companies Act both use the word may when setting out the methods by which which can be utilized to effect service. And my lords, we would have
Counsel, if I may quickly, the word may is used, but there are a number of possibilities in the section. It may be the address of the company, it may be directors of the company, it may be receivers of the company, it may be liquidators of the company. So that would it be comfortable to use the word shall in a section, in a provision like the one you're describing?
My lord, our submission in response to that would be that if the court had intended for there to be strict compliance with the ways for service which are set out in both the CPR and the Companies Act, that they would have used the word shall. And so the legislative intention of the drafters of both of those documents, my lord, I believe should be considered. And when taking that intention into consideration, my lord, we would submit that it was not their intention to limit the parties to those methods that are described in the CPR and the Companies Act, unless the court would have decided that whatever method of service was engaged was not correct and could not be corrected by the court.
Thank you.
Grateful, my lord.
Ms. Pinnock, I am interested in the view expressed, I think from a member of the bench earlier, that the fact that the other side entered a defense meant that they had returned to or submitted to the jurisdiction of the court. And in that sense, therefore, there was no irregularity to correct that the court was then seized of jurisdiction. Do you have a view on that?
My lord, I would agree with that view, especially my lord, in our circumstances, as you would have explained, where the parties had engaged in the procedure, had engaged in the court procedure, my lord, had submitted their acknowledgement of service, had submitted their defense in the matter, had went to many sessions of mediation, my lord, starting in 2020 and ending in 2021, when it was determined that mediation could not be successful. In those circumstances, my lord, we can also look at Rule 8, Rule 9.7, my apologies, of the Civil Procedure Rules, which state that if an objection is going to be taken to the jurisdiction of the court, that objection under normal circumstances should be made before the period for the filing of the defense elapses. So a party may put in there.
Repeat the section of the code.
The Rule 9.7 of the Eastern Caribbean Supreme Court rules, my lord.
And just summarize again for us what your understanding of it is.
My understanding, my lord, is that if a party is going to take an objection to the jurisdiction of the court, or in our specific circumstances, an objection to the way service was effected on them, that objection, my lord, should be taken within the period for the filing of the defense. And that is in accordance with the overriding objectives of the CPR, which include the saving of judicial time, the saving of costs, where the court does not envision matters proceeding, as in our case, proceeding for a year before a party decides to take an objection to how service was effected during the period of prescription, before the expiration of the period of prescription, my lord.
I see. Thank you.
Grateful, my lord. My lord, in our case, as you would have noted from the affidavit that was filed by the respondent, the applicant's registered address, as it is shown on its company documents, is described as John Compton Highway, Castries, in the state of Saint Lucia. And it is to be noted, my lords, that that location is actually a highway which stretches for many miles from Castries in Saint Lucia to Grosselet. And therefore, my lords, it is quite clear that there can be no service at that registered address because it is a stretch of respondent served the document on the receptionist of the applicant at a place that was closely connected with the claim, had a very real connection with the claim, which was the business address of the company at Barnard Hill Castries. We are submitting, my lords, that the claim was validly served upon them and that any irregularity in the service, where service was effected upon the receptionist instead of another officer of the company, that service could be cured by the court.
Mr. Pinnock, let me ask you a question. Under the Companies Act, if there is service at the address given as the registered address of the company, is that deemed to be good service?
Yes, my lord.
So if you all took these documents and served them and there is no company building on this highway, was there any company office on this highway?
No, my lord.
Right. So the company has no office on this highway, no building on this highway, and they say to the world to serve on us, serve it on us at the highway, and you took it and you nailed it on a tree in the highway. No, well, I mean, the company represents to the, I know it's ludicrous, isn't it? But I think it is interesting because the company has represented to the world that that's what you must do. What you have done is recognize the absurdity of what the company has represented and sort of try to seek out and find a practical and effective way to bring this to the company's attention. And now you are being criticized and being said, oh, you
And you
didn't follow.
successfully brought it to their
And
attention.
success, correct. And you are now
Yes.
being told, well, hold on, you did not follow the formalities of service. In other words, you should have nailed it on a tree. What's the name of the highway?
John Compton Highway, my lord.
Nail it on a tree on John Compton Highway, and we couldn't object. We would have been duly served. I don't know
Yes,
how
my
Mr.
lord.
Antoine, in his written note that Mr. Barrow has given him, it seems, presumptive permission to file. But Mr. Antoine, I would like to hear you on that. What would have constituted proper service under the Companies Act on your client? Where on Compton Highway?
Following on, sorry, Counsel, following on from my brother Jamadar's question, doesn't the Companies Act give you alternatives?
That's right. I'm coming to that. I was saying the Companies Act gives you alternative methods of service.
You would deal with those when Ms. Pinnock is finished.
Yes. Thank you.
Mr. Antoine.
You're muted, Ms. Pinnock.
My apologies, my lords. My lord, I wish to take you to the case of Pinner and Everett, where the court was describing in which I would wish to speak about the meaning of an enactment and how you decide what was intended by the legislator and how it corresponds with the literal meaning that is in the statute. In that case, my lords, it was stated, in determining the meaning of any word or phrase in a statute, the first question is, what is the natural or ordinary meaning of that word or phrase in its context in the statute? It is only when the meaning leads to some results which cannot reasonably be supposed to have been the intention of the legislator that it is proper to look out for some other permissible meaning of the word or phrase. Thus, my lords, based on the evaluation of that case, we are submitting that Parliament was deliberate in the usage of the word may in section 521 of the Companies Act, and that the language is not of an imperative character, and therefore the statute allows for a limited liability company to be served in other ways. And there's a repetition of the word may in Rule 5.7 of the CPR, my lord, and we submit that it was also another deliberate act taken by the drafters of the rules to ensure that the company could be served in ways that were not set out clearly in the rules. Once, my lords, that method of service was deemed to be correct by the court. My lords, we also wish to rely upon the case of Barbara Angela Reed against Melrock Investments Limited, trading as Access Cambio. And in that case, my lords, at paragraph 5 of the judgment, the learned master posited the following. This process seems to be quite an elaborate way of preventing documents from being received into the company. If the directors are not around, then it would appear that no authorization will be given to receive the documents. And if the directors are around, they have the option of not authorizing receipt. I am to point out to counsel for the defendant that the options set out in TPR Part 5.7 are options only. The word may as opposed to must is used, and this suggests that the claimant who wishes to serve the defendant is able to use any method which would get the document to the attention of the defendant. And my lords, we are therefore submitting that it is clear that the applicant in our case was validly served with the claim at its place of business, and it is further supported by the fact that they put in an acknowledgement of service into the matter, they put in a defense into the matter, thereafter attended numerous case management sittings and entered into mediation sessions, a number of mediation sessions, and thereafter, over 11 months after the commencement of the matter, during the or before the expiration of the prescription period, the parties then took the position that the matter was not properly served upon them. My lord, we wish to reiterate the point that the purpose of service of the claim form was achieved, and we will rely upon the case of Hodinot against Persimmon Homes Wessex Limited, where it was said at paragraph 54, Service of the claim form serves three purposes. The first is to notify the defendant that the claimant has embarked on a formal process of litigation and to inform him of the nature of the claim. The second is to enable the defendant to participate in the process and have some say in the way in which the claim is prosecuted. Until he has been served, the defendant may know that proceedings are likely to be issued, but he does not know for certain that he can do nothing to move things along. The third is to enable the court to control the litigation process. We are submitting, my lords, that in our case, all three aforementioned purposes of service were achieved, and that I at the risk of repeating, my lords, the applicants would have not only entered relevant documents into the claim, but would have also participated in the court process. Following from the above as well, my lords, we are submitting that this matter falls squarely into the realm of tacit renunciation, since the actions of the applicants clearly show that they joined the claimant on the merits of the claim and had abandoned or waived any right which they might have acquired to the defense of prescription. And we will rely on the case of Zussman Association, Lomdai Torah. The citation is 2015 QCCS 4832. In this case, my lords, the court has stated the following. As a result, as a matter of law, if the plaintiff can establish that the defendant renounced to prescription acquired or time elapsed within the 3-year prescription period prior to the institution of the claim in 2014, the action is not prescribed. It goes further in paragraph 14 to say renunciation of prescription can be express or tacit, which is similar to the provisions in our civil code. It goes further, paragraph 15, to say, as for whether these facts will be sufficient to constitute renunciation, the court adopts the following comments in the case of Riccardi and Capella. The promises referred to in the examination may not constitute at this point in time such a tacit renunciation, but the plaintiffs did not have a chance yet to proceed with a full hearing, including the examination of the defendant. As mentioned by the doctrine and case law, this is a question of facts to be determined by the trial judge once all testimonies and issues have been heard and argued. At paragraph 17 of that case, it was stated that when there are any doubts, the case law referred to above teaches also that the matter should be referred to the trial judge for a full hearing. The defendant will still be in a position to argue prescription. And as a result, my lords, in that case, the court held that as a result, the court concludes that the plaintiff might succeed in convincing a trial judge that the defendant renounced to prescription in 2012 and that her actions are not prescribed. In the circumstances, the court will dismiss the defendant's motion to dismiss. The defendant will have a right to argue prescription at trial, and the trial judge will decide the issue once all of the evidence is in the record. And following from that, my lords, we are therefore submitting that the issue of prescription is an issue for the trial judge, and therefore a matter ought not to be struck out if an application is made based on the issue of prescription. My lords, we would also rely on the pronouncements which are made in the Halsbury Laws of England in relation to what constitutes estoppel and conduct, which amounts to representation, my lords. And we would submit that the applicants in this matter are stopped from taking an unjust or unequitable position that they were never served with a document, having engaged the claimant on the merits of this claim, my lords. My lords, we also wish to make reference to Article 2087 of the Civil Code, which we would have noted that our learned friends had made mention of in their application. And my lords, they would have relied upon the article, the first section of that article, which states that prescription is not interrupted if the service or procedure be null from informality. And we're submitting, my lords, that refers to an act which can only take place if the court declares that the service was a nullity. And in our circumstances, my lords, we have noted that the court did not determine that the issue of service was a amounted to a nullity, but instead that it amounted to a procedural irregularity. And reliance, my lords, was placed on the cases of Bupa Insurance Limited, trading as Bupa Global against Roger Hunter, and Singh against Atombrook Limited. In the case of Bupa Insurance, my lords, the court stated, the framers of the CPR did not intend for every breach of the rules to be taken as invalidating the proceedings. And that would be so whether or not the particular rule that is engaged is stated in mandatory terms. Once the consequence of the breach of the rule is not provided for by the CPR or otherwise, then consideration must be given to the provisions of Rule 26.9 in determining the way forward in the proceedings. My lords, further support is seen in the case of Singh, where the court said that I would not suggest that service on a receptionist, an employee of the respondent, is not an office and not an officer, would render service of the claim and the accompanying documents a nullity. It is an irregularity. My lords, as far as the request was made for there to be a explanation of how the limitation of time under common law principles operates, we would have made reference to the case of First Citizens Bank Limited and Cheppy Boys Limited. And in that case, there was an appeal from a decision of the claimant, from a decision, my apologies, that the claimant could not proceed with its claim against the respondent because it was statute barred. And in coming to the decision, the Justice of Appeal in that case stated that it is relevant to note that Section 3(1)A does not extinguish the claimant's right to bring an action, but rather imposes a procedural bar which the defendant may raise. And therefore, the distinction that we would see, my lords, is that in matters involved in the Civil Code, it extinguishes the claimant's right to bring an action versus in the Limitation Act, it does not extinguish the claimant's right to bring an action, but imposes a procedural bar which the defendant may raise. However, in our matter, laws, we will take note of the fact that the claim was filed within the prescription period. It was served within the prescription period. The acknowledgement of service and the defense were both filed within the prescription period. And as we had indicated, the defendant would have participated in the court process within the prescription period. And my lords, on that basis, we are submitting that prescription was validly interrupted. My lords.
Sorry.
My lords.
No, I think you can go forward.
Unless I can be unless I can be of any further assistance, my lords, that is the extent of my submissions this morning.
Yeah, okay. You want to make any brief response, Mr. Antoine?
Microphone.
Thank you, my lord. Thank you, my lord. My lord, my brief response essentially is to, based on our application before the court, we raise certain points which have not been ventilated before the court this morning from our part, because as I said, I misunderstood what the court was asking for in terms of what was limited, what we are limited to speak on this morning. So I really want to request from the court permission to file submissions, to ventilate all the points. I think Barton, if for nothing more, is for the court to have its own view on the point. This is a Supreme Court decision on how original motions be done, and similar to our point in that it just simply indicates that you can't retrospectively cure a defect in service. You cannot choose any method of service, notwithstanding it says may, you can't choose any method of service. And that's why the rules go on to say, because even within our rules, the rule says you may personally serve X, Y, Z, but there's another part of the rules that says if you can't serve X, Y, Z, there's an alternative method of service. And that alternative method of service, you must come before the court to ask the court, can I serve this person that way? And you must show the court why you're able to serve that person that way to bring attention to the person. So it is not narrow as to say, well, it says may, and because it says may, then I could just choose whatever method that I want to, as long as it comes to the attention of the court. Barton says no. Barton says, no, you can't do that. Not for originating motions. You just can't decide because it comes to the attention of the person, because also have to decide because of the original motions, there's time to run and the limitation issues. So he uses the word, there's a bright line that goes through the case, where the court has to be certain as to where it started. And it just can't be a case where one decides to serve any way they want to and say, well, it will keep the attention of the defendant, so it is fine. The court says, no, you can't do so. So if, for nothing more, I would love the court to look at the issue and ventilate it for our own jurisprudence in the matter, given this is now our apex court. Would love to see what the court says on that point. On the point that Justice Burgess raised earlier on, I agree with him in that the may there again is giving you options as to methods of service. It is not allowing you to go outside of that. This is statute rules that says that you may serve a company A, B, C, D, E. It does not allow you to go outside of that and say, well, yeah, you said may, so because you said may, I could choose any method I want to and say it's good service. No. Again, Barton puts all that in perspective and says no and gives all the reasons. And I certainly want to put that case before the court and express it. Similarly, I would like to put before the court, my learned friend raised Rule 9.7, where it speaks of if one wants to, if you like, challenge jurisdiction of the court, one has to put acknowledgement of service in and then challenge jurisdiction of the court. We did not bring our application 9.7 because we would have been out of it. However, we brought it onto the case management powers of the courts in terms of dealing with preliminary issues which we dealt with. And again, we'll explain why we did that. And there's case law to support the two forms of jurisdiction. And our jurisdiction point we're raising was one of the locus standi. That's the point we're raising. And an issue of locus standi can be brought up any time in the proceedings. And that's what we sought to do in that matter. Well, I can't offer anything at this stage. Safe to say,
Mr. Antoine?
Yes, my lord.
If the panel allows you to make these further submissions, were you intending in the course of them to address what has arisen? My brother Jamadar's coconut tree on John Compton Highway metaphor, I think, evokes this. What stops this court from deeming service to have taken place at the registered office of the company not having provided a proper registered office? So what stops this court from deeming? The question is not whether it was served upon a receptionist or a secretary or an officer of the company, but rather this court saying, hold on, these people did not provide a true registered office. Therefore, wherever they carry on business, we shall deem that to be the registered office for purposes of service. And that is the end of the dispute. Tell me about that.
Lord, I would accept that position had there not been any other method of service. But the rules and indeed the Companies Act does provide other methods of service. That's why it says may.
Sorry, those provide what?
The rules and the Companies Act does provide other methods of service. So in our case, other methods of service.
Yeah, but I'm saying to you, you don't need to go to the other methods. Because if you, the company, fail to provide a legitimate registered office, you cannot turn around when I serve you at the place where you are conducting business, which is, as it were, the only thing that speaks to your physical location. If I serve you there, you cannot turn around, the court may say, and say it is not the formal registered office, and therefore we will not accept that as having been served at the registered office. That's what engages me.
My lord, while I see force of your argument, I would accept such an argument if that was the only method of service. But the rules and the Companies Act does provide other methods of service. The director of the company is well known. The director could have been served as he's been served before. The corporate secretary could have been served. A senior officer of the company could have been served. There are different methods of service.
Yeah, but what you are saying, Mr. Antoine, you are saying that we must accede to the situation where you fail to do the fundamental thing, to provide a legitimate registered office to which I could have sent this process by registered post. I don't have to seek out anybody. I can send this by post.
Well, my lord, in accordance with the Companies Act, the company's registry accepted that being, and I'm not suggesting at all it is a good place of service, but the company's registry accepted that document as the registered address for the company.
So maybe this court should make a comment that the company's registry need to do better than that.
Indeed, my lord. Indeed, my lord. Yeah, but that is the registered office of the company. And I accept it's not proper registered office.
Sorry, no, Mr. Antoine, no, don't go too far. Not that is the registered office. There's no way. It's not that is the registered office. It is that the company's registry, as you see, allowed that to take place.
And that is why the rules and indeed the Companies Act gives options. So if you can't get one, you get another. So there were options that the claimants could have exercised.
We are going in circles, Mr. Antoine.
Very well, my lord.
Yes, is there anything else, Mr. Antoine?
No, my lord, just that I make an oral request or application.
Yeah, I've heard you on that. And
Yes,
we would
thank you, my
give you 7 days. So that today is what, the 12th? You will make further written submissions on the 20th. And
Sorry, my lord, what day is the 20th? Would it be next
20th is a Friday.
Yeah, thank you. Yes.
Yes. And the other side would have a right to respond, and they would give us those submissions on the 27th. And the court would not need to hear from you orally unless we specifically require that. But
President, can we confine the length of the submissions to 3 pages? Yes. Thanks.
Yes. How much time you want? How many pages do you think you need to supplement your written submissions, Mr. Antoine?
I believe 5 pages may do, given the spacing and the margin.
You want to go longer than we allowed you in the primary speaking notes? Come on, Mr. Antoine.
My lord, I hope this case is also important from a jurisdictional point of view, that I think the court should allow some latitude in how the matter is properly ventilated.
I think giving you the hearing was the president's acknowledgement of the importance of the jurisdictional issue, giving you the oral hearing instead of disposing of this on paper.
Indeed, my lord. Indeed, my lord.
So you give him 4 pages. And equally, Ms. Pinnock, you would have 4 pages. And of course, the font size and the margin width and so on, the spacing would conform to the original order that was made.
Much obliged, my lord.
Yeah. Okay. I think that's the end of our business this morning. Just to repeat, the counsel for the applicant would have until the 20th, by close of business on the 20th, to make further written submissions. Counsel for the respondent would have until the 27th, and the court will proceed to render a judgment on the basis of the written submissions that have been made, as well as the oral submissions today, unless, of course, the court wishes specifically to hear you further orally, in which case we will certainly let you know. So thanks again to counsel for your submissions, and Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. And thank you, Mr. Justice Jamada. Thank you, counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Okay.